Hello everybody, welcome to EPG Pathshala. I'm Monica Sakrani. We'll be looking at the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989 as amended in 2015 for the course Legal Literacy. How did this act come into being? This has a history. We all know that India has a terrible history of caste atrocity and caste discrimination. When the constitution was framed, untouchability was abolished under Article 17 of the Constitution. Another very important article which tried to address the issue was Article 23, which prohibited begar and other forms of compulsory labor. And these are fundamental rights. Now, the first law which actually came about post-constitution or post-independence was the Untouchability Offences Act 1955, which prohibited social and religious disabilities. So like for example, taking water from a well or using a right to way or entering into a temple. So all these were the social disabilities which were there or the religious disabilities which were there were done away with. Now this act was amended and it was made an offense if anybody practiced that. Now this act was further amended in 1976 and named as the Protection of Civil Rights Act. So this was, the whole approach was of civil rights and enforcement of civil rights of the people belonging to the scheduled caste and scheduled tribe communities who were suffering from untouchability. But in 1989, because caste atrocities became rampant, the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act was passed, which specifically made certain acts which were done at the individual level an offense, and basically took the approach of prosecution of offenses against SC/STs, rehabilitation of victims of atrocities, and how the state should gear up to prevent these kind of atrocities and protect the victims. Now, despite this law, there were many, because of certain loopholes in this law or lackadaisical nature of implementation of the law, caste atrocities have been rising in this country, and the conviction rate for offences against SCs and STs in 2015 was 27%, a little over 27%, which was much lower than the conviction rate for all offences under the Indian Penal Code, which is and special laws, which was 80%. So this act changes were made in this act. Certain parts which were there in the rules have been now put in the act, in the statute book itself, to give it more strength and make it more workable and more stringent. Now, the most basic part of the act is that it defines what is an atrocity. Now, the list of atrocities has been revised and added to in the 2015 Act, and the entire list you will get in your e-text. But atrocities are acts which are committed by non-SC/ST to an SC/ST, which is punishable with imprisonment for a term which shall not be less than 6 months, which may extend to 5 years, and with fine. There are certain offences which are punishable with more. These include, for example, dumping of excreta, making somebody eat an obnoxious substance, garlanding with footwear or parading naked or semi-naked, forcibly removing clothes of a person, forcibly tonsuring of head, wrongfully occupying or cultivating land, including changing the land records and forcing someone to hand over the land to that person, forcing a person to do begar or bonded labor, dedication of woman as devdasi, prevention of exercise of right to vote, or forcing a person to vote for a particular candidate or not vote for a particular candidate, prevention of exercise of right to stand for election. So it should be stand for elections or perform their duty as a member of the panchayat or a municipal body, or as the chairperson of any of these bodies. Threatening to impose social or economic boycott or preventing from availing benefits of any public service, instituting false, malicious or vexatious suit or criminal or other proceedings, abusing a person by the caste name in any place within a public view, destroying, damaging or defiling any object including statue, photograph and portrait generally known to be held sacred or in high esteem, by words either written or spoken, or by any other means disrespecting any late person held in high esteem. So this has been included in the 2015 amendment. Intentionally touching a woman in a sexual manner knowing she's SC/ST without her consent. Now in this case also consent has been broadly defined, similar to that a person's consent is not, if she has not expressly consented, it does not mean that she has consented. Corrupting or fouling the water of any spring, reservoir, or any other source, denying the use of or obstructing the use of any customary rite of passage or place of public resort, obstructing or preventing use of common property resources, burial or cremation grounds, river, stream, spring, well, tank, cistern, water, any water resources, bathing ghat, any public conveyance, any road or any passage. Obstructing or preventing in any manner from mounting or riding bicycles or motor bicycles, or wearing footwear or new clothes in public places, or taking out wedding procession, or mounting a horse or any other vehicle during a wedding procession. Obstructing or preventing in any manner from entering any place of worship which is open to the public. Obstructing or preventing in any manner from entering into any educational institution, hospital, dispensary, primary health center, shop or place of public entertainment, or any other public space. Obstructing or preventing from practicing any profession or carrying out of any occupation, trade, business or employment. So forcing a person to only carry out their traditional occupations. Causing physical harm or mental agony on the allegation of practicing witchcraft or being a witch. Imposing or threatening a social or economic boycott on any person or family or group. Giving or fabricating false evidence. If the person is convicted in a capital offense and dies, then it is life imprisonment or death. Otherwise, if I just give or fabricate false evidence in any other kind of a case, then it is 6 months imprisonment minimum up to a maximum of 7 years of imprisonment. If I cause damage to property with fire or explosive substance, then it is minimum 6 months of imprisonment up to 7 years. But if the place is a place of worship or a dwelling house, then that imprisonment would extend to life imprisonment. Now you have a list of atrocities, but there's also a procedure. The Act does not just give substantive provisions of what is an offense. Apart from that, if any offense committed under the Indian Penal Code, then the punishment for that would be life imprisonment. So you have other list of offences, but you also have a specific procedural requirements for these offences. Now the courts which are set up, there are special courts which are set up. This was set up even in the earlier Act of 1989. Now under the 2015 Act, exclusive special courts have to be set up. They are at the level of Sessions Court. If there aren't enough cases under the Atrocities Act which are filed in that particular district, then one Sessions Court can be designated as a special court. Otherwise, there has to be a dedicated exclusive Sessions Court, special court. Special public prosecutors have to be appointed, which are taken from a list of senior lawyers in that particular district with over 7 years of standing. Preventive arrests have to be made by the court, can order preventive arrest if information that atrocity may be committed. The other important requirement is that no anticipatory bail is to be granted, but the Supreme Court has held that if prima facie case is made out, only then no anticipatory bail should be granted. Otherwise, if no prima facie case out under the Act is made out, anticipatory bail will lie. So it is very important that when a complaint is filed under the Act, then ingredients of the offence under this particular Act has to be made out, details have to be given. Another important provision under the law is that if a person is convicted under this law, then he is not entitled to probation, that is release on good conduct. Trial has to be videographed. The court also has to ensure that the victim and the witnesses are protected and relocated whenever required. They have to get traveling and maintenance expenses with socio-economic rehabilitation during investigation, inquiry and trial. The court also has to ensure that where required, the names and identities of the victims and the witnesses should be concealed. Any complaint made by a victim that he's being harassed in any manner by the accused or any other person, whether it's the victim or the informant or the witness, the court has to order the action on the same day, and the police has to be directed to take action, and the hearing of that case would go on. The other rights of the victims are that reasonable, accurate and timely notice of any court proceeding, including bail proceeding, by the special public prosecutor of the state. They have the right to apply to the court to summon parties for production of any document or material, witnesses, or examine any person present. They have the right to be heard in any proceeding in respect of bail, discharge, release, parole, conviction or sentence of any accused, or any connected proceedings or arguments, and file written submission on conviction, acquittal and sentencing. So they have a right to participate in the proceedings, and they have a right to be informed about which stage of the proceedings are going on by the special public prosecutor or the state. The victim also has a very important right, which is the right to compensation. So the rules have been, there's a schedule attached to the rules under this act, which set out the quantum of compensation to be paid to the victim or the victim's family. So all the list of all the offences and what kind of compensation has to be paid, the amount of compensation to be paid under each of the categories of the atrocities is set out over there. Part of the money has to be paid at the time of filing of the FIR, part of the money at the time of filing of the charge sheet, and part of the money at the time of conviction. Under the earlier act and the rules, most of the money was being paid at the time after the conviction, and this also led to a kind of a reverse incentive for low rates of conviction. So now most of the money has to be paid before the conviction or before the stage of conviction. Another very, very important change made in the 2015 Act is earlier one of the reasons for the failure of the Act was that the burden of proof was on the victim. So if the accused could always say that I did not know that you were a member of the SCST, and therefore the atrocity itself failed to be proved. So now the most important changes have been made is the last one over here, which is where the accused was having personal knowledge of the victim or his family. The court shall presume that the victim was aware, that the accused was aware of the caste or tribal identity of the victim unless contrary is proved. So now if I know you, I will be presumed to know which caste you belong to, and I have to prove that I did not know that you belong to the SC/ST caste if I have committed an atrocity. Apart from that, rendering any financial assistance or giving any kind of monetary support in relation to offence committed by a person accused of or reasonably suspected of committing an offence under this Act is abetment of the offence unless contrary is proved. So I will be presumed to have abetted an offence if I in any way financially support the committing of the offence. The third presumption is that where a group of persons committed an offence under this Act, and if it is proved that the offence committed was sequel to any existing dispute regarding land or other matter, that the offence was committed in furtherance of the common intention or in prosecution of the common object. So this is really, if we look at the facts of the Khairlanji case, where there was a land dispute and there was a murder and a brutal murder and rape of the women and the family members, then in this case there's a direct connection that it would be considered to be in common object and common intention, and it would be considered to be an atrocity, and there would be a link between the two offences. Now the police and public servants have been cast the duty under this Act. The most important are that you have to file a FIR immediately. The accurate recording of the FIR has to be made. The person has to be read over the FIR, explained what is written in the contents of the FIR before the signature is obtained. Adding sections under the Act, so there should be the police should not fail to add sections under the Act wherever it applies. They have to register the FIR under this Act and not just under the general sections of Indian Penal Code. They have to furnish a copy of the FIR to the informant free of cost, and the investigation has to be carried out by the officer not below the rank of the deputy superintendent of police. It can be of a higher rank but not lower rank. Investigation has to be completed and the charge sheet has to be filed within 60 days. If it is not done, then reasons have to be given for why the investigation is not complete and the charge sheet has not been filed under 60 days. So irrespective of whether the charge sheet can be, if the offence is punishable with more than 10 years and charge sheet can be filed within 90 days, if it is Atrocities Act, then it has to be filed within 60 days. The state also has duties. One is that immediate relief has to be given in cash or in kind. Whatever the victims and the witnesses have to be given protection. They have to be given relief in respect of death or injury or damage to property. Arrange for food, water or clothing or shelter or medical aid or transport facilities or daily allowance to victims where they have been, where they have lost their houses or they've been forced to flee their place. Maintenance expenses have to be given. They have to be given information about the right of atrocity victims at the time of making complaints and registration of FIR. So you have to be informed that you have a right to seek maintenance, you have a right to relief, you have a right to compensation, you have a right to be informed about the participation in the case. Legal aid is a right. So all these, the victim has to be informed, and it is not the other way around that the victim asks for these and therefore they are given. The state and the public servants have a duty cast upon them to inform the victims of their rights. They also have a right to be protected from intimidation and harassment, necessary precautions at the time of medical examination, information about the relief amount, the stages at which it has to be given to them, information in advance about the dates and place of investigation and trial. They have to be given briefing on the case and preparation for trial and provide legal aid, economic and social rehabilitation of the victims of atrocities. The state also has to take preventive powers, preventive steps. One is that an atrocity has taken place, so how do you investigate properly? You provide rehabilitation and relief and protection to the victim. You provide proper participation in the court. You provide a court structure which gives justice, and you provide a framework of trial of these offences. Apart from that, they also have a duty to prevent atrocities from taking place. So there has to be a nodal officer appointed who is the level of the secretary. They have to make budgetary allocations so that whatever steps have to be taken, relief has to be granted. There is enough money for that. They have to identify areas where SC/ST are likely to be subjected to atrocities and take whatever steps are required to ensure their safety. They have the right to preventively arrest people in order to prevent an atrocity from taking place, or if it is likely to take place. There is also a high-powered vigilance and monitoring committee to be appointed at the state level to look into the implementation of the Act, to monitor the implementation of the Act. And also this committee has to have subcommittees at the district and subdivisional level. This committee also has to, and the government also has to review biannually the implementation of the Act and how it is being done. So reports are called for from every officer to see all cases have to be monitored at the level of the state and at the level of the Vigilance and Monitoring Committee. When an atrocity takes place, the district magistrate or the subdivisional magistrate or any executive magistrate or a police officer not below the rank of a deputy superintendent of police has to visit the area to judge the extent of atrocity, loss of life, loss and damage to property, and submit a report forthwith to the state government. He or she, these officers also have to take steps to prevent the occurrence and protect and provide immediate relief to the victims in cash or in kind, or both, within 7 days, which shall include food, water, clothing, shelter, medical aid, transport facilities and other essential items. If there is a threat to commission of atrocity, then these officers, upon receiving information that a person or a group of persons not belonging to SC/ST residing in or frequenting any place within the local limits of his jurisdiction is likely to commit an offence or has threatened to commit an offence, and is of the opinion that there is sufficient ground for proceeding, declare such an area to be an area prone to atrocities and take necessary action for keeping peace and good behavior and maintenance of public order and tranquility, and may take preventive action again under the CRPC, which includes filing of chapter cases or prohibitory orders under section 144. So they have to take all these steps if there is a threat to commit an atrocity. Apart from that, the state also has to set up a SC/ST protection cell, which will be at the police headquarters to ensure that no atrocity takes place in the areas identified by it. So these are the areas which are prone to atrocities, maintaining public order and tranquility in the identified areas, making investigations about probable causes of an offense, restoring the feeling of security amongst SC/STs, and reviewing the position of cases registered under the Act. We have looked at the provisions of the SC/ST Act, and we have got an understanding of how it functions, what are the changes which have been made into it to strengthen it, and you can look at the e-text. You can also look at read the Act and the rules under the Act, which are very important. So not only that, but also committing of any offence specified in the schedule to the Act against a person or property, knowing that the person is a member of the scheduled caste or scheduled tribe, or that the property belongs to this person, shall be punishable as specified in the IPC. Apart from that, even any attempt to cause any destruction of evidence or disappearance of evidence or tampering with the witnesses is also an offence which is punishable with the same punishment which is there provided for that particular offence with regards to which this offence has been committed, or any attempt to screen the offender or to tamper with the evidence is also a punishable offence. Any public servant who commits any offence under this provision is also punishable with imprisonment for a term which will not be less than 1 year, but which may extend to punishment provided for this offence. Now, what we need to understand with regards to atrocities is that it is not just acts which are individual in nature, though there are individual acts, but these are also very social and structural acts which are conducted not just alone by people, but as a kind of a social phenomena. And sometimes they are not targeted, it does not just target the victim, it targets also the community. So the amendments to the Atrocities Act, the first time when the Atrocities Act was passed, what it tried to do is, because the Protection of Civil Rights Act and the Untouchability Act tried to address the social aspects of untouchability or caste discrimination, what the Atrocities Act tried to do was address the individual aspects of caste discrimination, and atrocity has been defined as a very gross kind of an offence. So though it is not technically defined in any law or in the Indian Penal Code, it is understood in a social sense as a very serious offence or a very gross or grave offence. So these are not just offences under the Indian Penal Code, many of these are offences and they have been defined, but there's no social context to those offences. They are between two individuals, whereas this makes it a contextual to a certain social condition or a social behavior or a pattern that one wants to address and change. That is to form a caste free society, or to have a society in which there is no caste discrimination. And therefore these offences have been classified as atrocities and dealt with specifically, even though many of them are actually covered under the Indian Penal Code. And therefore the violation, and because they are conducted in a particular social context, the victims are at a disadvantaged position. So in any offence, it is not necessary that, in fact we know that criminal law, the way criminal law operates as social workers, we know that it operates in a domain where most of the accused are poor and they belong to the disadvantaged sections. But in atrocities, it is the reverse. The victim belongs to a disadvantaged position, whereas the accused is at an socially advantaged position. So the victim is twice disadvantaged in this, that you are a victim of an offence, and plus in the system itself you are you're powerless and you're pitted against somebody who's more powerful. So you're more likely to come under threat of the pressure of the accused, and therefore that kind of protection and that recognition that you are disadvantaged thus is there by bringing in these offences under the Act. Appeals against any decision of the courts in the matter under this Act have to be filed within 90 days, up to a maximum of 180 days. So an appeal cannot be filed beyond a period of 180 days. If there is any offence which is taken place with regards to this, or a threat of an offence which is taking place, then the court can also extern the person, the accused, from that particular place. Externment is when you tell a person not to be in a particular area, to leave that particular area. So up to 3 years of externment can be done in cases under this Act. The victim also, the court also has to, the state has the responsibility to make arrangements for the protection of victims, their dependents and witnesses against any kind of intimidation and coercion or inducement or violence or threat of violence. So all kinds of protection, and it is the responsibility of the state to do that. Victim shall be treated with fairness, respect, dignity, and with due regard to any special need that arises because of the victim's age or gender or educational disadvantage or poverty. So as we said, that this Act recognizes that the victim is at a disadvantaged position and seeks to protect it, and it is the responsibility of the state to do that. Many of these provisions were actually there in the rules in the 1989 Act. They have been brought into the main statute book and given a legal character and enforceable right to the victims of atrocities. This Act also has a role for NGOs and organizations that assist persons who are victims of atrocities. So a victim of an atrocity has the right to take assistance of an NGO, and information has to be provided to him. NGOs can also participate in the proceedings and help the victim, and that kind of space is provided to it. The state government also has the right to impose collective fines for the violation of this Act, and has to make, as already stated, a provision in the annual budget with regards to the implementation of the Act. The Director General of Police, the IG, has to, Director Inspector General of the Police has to play a role in seeing that the Act is being properly implemented. So now there are more stringent provisions to ensure that the Act is properly implemented, because one of the main criticisms against the manner in which the Act was being implemented was that there was a lack of commitment on the part of the officers who were responsible for the implementation of the Act to do it in the letter and spirit in which it was meant to be operated. So this loophole has been tried to be fixed in the new amendments which have come into the law. Thank you.